Good day everyone, and I hope you're safe and well. I'm Sofia Casana D. Reyes, and the case that we presented to you for today is the case of Price Corporation, formerly known as Price Property Corporation or PPC, versus the defendants Philippine Amusement and Gaming Corporation or the PAGCOR. General Register number is 157480, dated May 6, 2005. Before anything else, let me tell you the facts of this case. Sometime in the first half of the year 1992, the representatives of the petitioner or PPC made the representations with the defendant or PAGCOR to set up a casino in Price Plaza Hotel located at Cagayan de Oro City. On November 11, 1992, both parties executed a contract of lease. On November 13, 1992, they executed the addendum of the contract, which includes a lease of an additional 1,000 square meters of the hotel grounds as the living quarters of the casino personnel. PAGCOR then advertised the start of their casino operations on December 18, 1992. However, in 1990, the Sangguniang Panlungsod of Cagayan de Oro City declared a policy prohibiting the establishment of any gambling casino in the city. Going back in the year 1992, on December 8, hours before the formal opening of the casino, a public rally by some local officials, residents, and religious leaders occurred in front of the hotel. The defendants were constrained to suspend operations due to that occurrence. To cut a long story short, both parties fought for their rights to operate the casino, and the Court of Appeals allowed their operations. Henceforth, PAGCOR resumed its operations on July 15, 1993, but there was another rally, but they still proceeded. However, they suspended their operations later on due to incessant demonstrations. PAGCOR decided to stop their operations prior to September 1993 since there was a verbal advice from the Office of the President of the Philippines. In two statements of account dated September 1, 1993, the petitioners apprised the defendants' outstanding account for September 1 to November 13, 1993. On September 3, 1993, the petitioners sent another letter as a follow-up to the earlier conference of the party. On September 15 of the same year, they sent another letter stating that the Board of Directors' decision is to collect the full rentals in case of pre-termination of the lease. Then on September 20, 1993, the defendant sent the petitioner a letter stating that it was not amendable to the full payment of rental because what happened is due to unforeseen legal and other circumstances which prevented them from complying with their obligations. Furthermore, the defendant stated that they had no other alternative but to pre-terminate the lease agreement. In a letter dated October 12, 1993, the defendants asked the petitioner to refund the total of 1,447,582.25 pesos, representing the reimbursable rental deposits and expenses for the permanent improvement of the hotel's parking lot. So much of that, we then proceed to the petitioner's claim. Other than they made representations with the defendant, they stated that they have the right to collect the future rental since it is stipulated in their contracts. Furthermore, they also claim that they only have the right to resign the contract and that the decision of the defendants to pre-terminate the contract is not proper. On the other hand, the defendants claim that they are incapable of paying the full rentals since the stoppage of their operation is due to fortuitous event that forced them to terminate the agreement even before the petitioner's decision. They also contend that the petitioners have no right to collect the future rentals because they chose to resign the contract. For the decisions of the lower court, the ruling of the Court of Appeal stated that the decisions of the defendants to pre-terminate the contract is unjustified because the public demonstrations and rallies are not considered as fortuitous events and the termination of agreement is only valid at the date that the petitioner elected to terminate it. When the contract is effective, PPC can still collect the accrued rentals, but they could not demand any payment from the time they chose to terminate it. The court carefully deliberated the claims of both parties. It decided that the petitioner does not intend to resign the contract but only terminate it. Regarding the future rentals, since it is stipulated in the contract that the lessee shall be held liable for any damages resulting to the termination of the contract, therefore, the defendant must be held liable to pay for its obligations. The issue for this case is whether or not the defendants have the right to pre-terminate the agreement with the petitioners and are they liable to pay the future rentals to PPC. Moreover, in the disposition of the case, the prior decision is modified regarding the amounts to be paid by the defendant from 7,037,835 pesos and 40 centavos to 687,289 pesos and 50 centavos. And regarding the accrued rentals with 2% interest per month, the attorney's fees are affirmed. Lastly, the dictum. According to Article 1191, the power to resign the obligation is implied in reciprocal ones. In case one of the obligors should not comply with what is incumbent upon him, the injured party, which is in this case the petitioner, may choose between the fulfillment and rescission of the obligation, with the payment of the damages in either case. He may also seek rescission even after he has chosen fulfillment if the latter become impossible. And that's it. Again, this is the case of Price Corporation versus the Philippine Amusement and Gaming Corporation. General Register number is 157480, dated May 6, 2005. Thank you and have a great day.